everyone. Thank you so much for joining this webinar, which is very timely given the fact that there is a lot of updating to do today around the H-1B and the $100,000 fee. There's been changes throughout the past few months that have evolved. Everything is changing pretty quickly. And so we at Build want to make sure that we are able to provide timely information and answer questions and talk through these changes as they happen, because there's a lot of news and there's a lot of considerations as everyone thinks about what next steps would be in terms of H-1B sponsorship, what backup plans exist. So just to introduce ourselves, my name is Danielle Goldman. I'm CEO of the Build Talent Labs. We just rebranded because we have new programs that are all fall within these innovative solutions in the immigration space, one of which is the Build Fellowship Cap-exempt H-1B program. But Jeff and I co-founded Build, and we are continuing to think very creatively about the space and obviously within compliance. So we're really happy to talk to you about the news today, but we're also going to talk about some of the solutions that companies should be thinking about right now. So Jeff, I'll turn over to you to introduce yourself to folks on the call, and then we'll jump in.
Thanks, Danielle. I'm Jeff Goldman. I'm Danielle's dad, and I am co-founder with her of Build Talent Labs. So I'm also an immigration lawyer for now 31 years, practicing strictly in immigration law. And within that area, I only practice employment-based immigration, concentrating on strategic paths for entrepreneurs and founders.
Awesome. I see on the call today we have a mix of folks. So we have foreign nationals. I see some of our company partners. We also have some immigration attorneys. So will be a really interesting conversation as we dive into what we know and also what the impact is on companies and what the options are ahead of us. So thank you all for being here. Here's just the lay of the land as we jump in here. Last year, September 19th, I make a joke with anyone in the immigration space that everyone knows where they were that evening. It was a Friday because that is when the government, the administration put out a proclamation announcing a $100,000 fee for H-1Bs with not much guidance at the time. Since over the last year, we have learned, of course, that this was specifically a fee that the administration put in place on individuals coming on H-1B from abroad through consular processing, not individuals here who were applying for a change of status. So over the last year, we've seen some companies go ahead and pay that $100,000 fee, and many companies did not sponsor individuals through H-1B pathways because of this fee. And then after multiple lawsuits were filed, it took quite some time to actually get through those court decisions. But on June 8th, last month, we did see that there was a court ruling in the federal court in Massachusetts that overturned the administration's proclamation, saying that it was not within the administration's authority to place this fee on H-1Bs. That was quickly met with an appeal from the Trump administration, and therefore we were in limbo over the last few weeks, not knowing whether or not the Trump administration's appeal would mean that the $100,000 fee stayed in place or whether it was overturned during the litigation. We didn't know what would happen, what would stay, and what we would have as a current, world that would we be able to file these visas while this litigation is pending or not. So Jeff, that's sort of the landscape that we have found ourselves in. And then July 24th on Friday last week, we get new news that there's been more action in this case. Can you just talk about what we learned on Friday and what this has meant for folks around the $100,000 fee?
Yes. The U.S. Court of Appeals for the First Circuit heard arguments from both sides on whether not on the merits of the case, of whether or not there should be a $100,000 fee, but they heard arguments on whether they should stay the $100,000 fee, pause it while the litigation continues, or whether they should keep it in place and have it being enforced while the litigation continues. And they came out with this decision this past Friday that said they do not think that the government is likely to succeed in this litigation. They didn't make a decision, but they said they're unlikely to succeed. Frankly, they weren't buying any of it that the government said. Why the government argued they have the right to impose a $100,000 fee. The plaintiffs in the case argued only Congress can impose fees, not the president. The court agreed with the plaintiffs, and the court said, we are not going to stay the lower court's decision. So what they decided is going to start right away to be enforced, which means no $100,000 fee. That's what the lower court said. And the appeals court said to the government, you can continue with this appeal and we'll go through the whole appellate process. That can take a very long time, but while this is ongoing, there's no $100,000 fee. So where are we right now? No $100,000 fee. However, the government, the Trump administration, has the right to immediately file an appeal, just not on the merits of the case, because that hasn't been even decided yet by the appeals court, but they can go to the Supreme Court and argue that the Court of Appeals was wrong to refuse to stay the lower court decision. So that's where we're at. And it is widely expected that the government will appeal to the Supreme Court because Trump appeals everything to the Supreme Court when he doesn't like the decision. And we have no way of knowing exactly how this will turn out. I have my own thoughts as a lawyer practicing in this area for 30 years. I think the Supreme Court will not get involved. I think they'll either refuse to consider this request from the Trump administration, or they will consider it, but they won't agree with Trump. And they're going to say the litigation can continue, but the courts have spoken. This is unlikely to succeed. And so we're going to stop the $100,000 fee while the litigation continues. That's what I think will happen.
So this is a ping pong match that's going on, seemingly, and there are multiple tools that the administration has to really continue on through this litigation to stop folks from moving forward with filing H-1Bs right now. How much time are you advising companies that during this period where the court's decision to block the $100,000 fee is in place, and technically right now today there is no fee due upon filing for these consular cases, are you telling companies to move forward with cases if they can right now? And how much time is your law firm anticipating you have if you are filing before the Supreme Court gets involved? And are how are you premeditating some of this?
Right. I am advising companies to move forward and file right now H-1B petitions that they didn't file because they were going to be subject to the $100,000 fee. They have to assess the risk. I think there's not a high risk, because let's just say the Supreme Court in 1 month, and I do think it'll only be about a month, in 1 month they say, you know what, we're going to agree with the Trump administration that while the litigation continues, and it could take a long time, there will be a $100,000 fee. I don't think they'll do that, but they could. And what if they did? Well, I think the risk to all of those clients of mine who I advised to file, if they filed, they could suddenly get an invoice from the government for 100,000 saying, we're going to stop the processing till you pay the 100,000, or we've already approved the H-1B, but we're going to void it. We're going to file a notice of intent to revoke the approval if you don't pay the 100,000. And then what happens? If the company does not want to pay the 100,000, the only negative is they've now paid legal fees and the regular government filing fees. And if they don't want to pay the 100,000 and they want to just withdraw the petition, so they've lost the legal fees and the government filing fees. But I think that is somewhat of a low cost when you're thinking about there's a very good chance they're going to be able to get this approved without paying the $100,000.
Mm-hmm. That's really interesting. I mean, there's a few assumptions in that, right? The assumption that the Trump administration will take this to the Supreme Court, and obviously the assumption that the Trump administration decides to retroactively apply this to individuals who filed within a period of time when technically it was legal to file without the fee. So if those two assumptions are true,
Right.
then you have the maximum amount of risk in filing during this period of time. If one or the other is not true, then obviously more limited risk. I do think it's an interesting decision point for the Trump administration whether or not they bring this to the Supreme Court. On one hand, we know that the Trump administration does not like to lose. On the other hand, the proclamation is set to expire on September 19th. And that means that technically this trial year of seeing what the impact was on this proclamation and the effect of it is over. And so I'm curious if you think that there's a possibility that the Trump administration says, well, the 1 year's over, we'd rather sort of dip out now and just not renew this proclamation because maybe they've made other adjustments to the H-1B lottery with the wage-based rule, where they think they've sufficiently, sort of cured the fraud in other ways, and therefore maybe they just don't renew it, and they don't have to continue this litigation. Obviously, they're fighting on multiple fronts, many battles, specifically in the immigration space, but across the board. So do you think that there's a world where this sort of goes under the radar and just doesn't renew?
I do. And I'm glad you brought that up. I think the Trump administration, as they're reflecting on the effect of this over the past year, will say that it's been a huge success. Number one, I think their biggest goal, which they don't publicly state, but I do think their biggest goal was to create as much chaos and confusion as possible, and two, cast a negative light on the H-1B visa to exhaust employers
Yep.
and just get them fed up with the whole thing. And they'll say, we succeeded a lot. And they have to some extent. So I think that internally they'll say it's been a big success. I think externally they'll start boasting about the amount of fraud that they have uncovered during this time period, that it's been a success, and now they're ready to move on to other efforts
Right.
to
Yeah.
supposedly get rid of fraud in the immigration world. I also think they're really tired of losing at the Supreme Court. I mean, yes, they've won a couple of arguments at the Supreme Court, but they're losing almost every immigration argument they're making. So they
Right.
may just not go to the Supreme Court and let it die a death that was going to happen anyway in September.
Right. Yeah, I mean it's an interesting possibility, and it's a little bit of unknown. There is some certainty for folks right now that that there is an ability to file H-1Bs this current moment, this week, this month, for folks interested in moving fast on talent that they had very much wanted to put into the H-1B lottery, talent that they were ready to sponsor for cap-exempt H-1Bs. Can you talk through who right now might find themselves in a position where a company could move forward with sponsorship fairly quickly?
Yes, yes. There are companies out there that are trying to hire people who previously won the lottery, and now they might be outside the US. They have won the lottery. They are not subject to a new lottery, and any US employer can immediately file for them, but they're outside the US, so they would have had to pay a $100,000 fee, but now they don't. These people should be moving ahead and filing. The employers should be filing right now for them. My office has two that we even know about right now that we're already in touch with the employers, and they're like thrilled and they want us to move ahead and file without paying the fee. They understood the risk, that there could be a small chance the Supreme Court comes back and says they have to pay, but they're willing to take that risk. So we're working on those. Another group of people would be people who won this last year's lottery, and filed their H-1B petition for people who were outside the US and paid the $100,000 fee.
Mm.
As you said, Danielle, some employers did pay the $100,000 fee. We only had one employer. We helped pay the $100,000 fee. That employer already spoke to us this morning, and they want us to immediately start whatever action we need to take to get back the $100,000 fee. So while they already did move forward, and by the way, that employee ended up, we paid the fee, we got the approval. That employee already has been to the consulate and it sailed through. There was not even a question. They brought proof with them that they had paid the $100,000 fee, but the consulate already knew it and was fine, and it all went through smoothly. But we're already starting action to get back $100,000 that they paid. And then the biggest group of people affected by this are people who have never filed at all yet, but now they have a cap-exempt employer who's willing to move ahead and file an H-1B petition without paying the $100,000 fee. And Danielle, you can talk about cap-exempt H-1Bs. I can bring it up, whatever you want to do about that.
Yeah, I think if you could just give the different scenarios of cap-exempt H-1Bs that folks might be leveraging right now or thinking about. There are many folks on the call that might not realize they're eligible for a cap-exempt H-1B within their current positions or within positions they're eligible potentially to get. And then we could talk about the build program and how it's a good solution for folks that don't have a cap-exempt employer.
Sure. So as I think everyone on the call understands, there's a limited number of H-1Bs every year. There's only 85,000. The demand exceeds 300, 400,000 a year every year. So the U.S. Immigration Service conducts a lottery and picks out the 85,000 winners. The lottery is every March. This past March, they conducted a lottery. They picked out the 85,000 winners, notified those winners, and those companies had until June 30th to file an H-1B petition. Many of those petitions have not been approved yet, but if you had to pay the $100,000, you had to pay it at the time you filed, and that deadline was June 30th. So for these people who won the lottery this past March, they should have been paying the $100,000 already if they needed to. However, in the immigration law, Congress put in a section for cap-exempt H-1Bs. These are for 4 different kinds of organizations who are so important to the United States economy or the United States culture that Congress said they're exempt from needing to be counted in that 85,000 cap. These four organizations are universities, nonprofit organizations affiliated with a university, nonprofit research organizations, and government research organizations. So these four organizations can always file a cap-exempt H-1B on behalf of a foreign national so that that foreign national can come work for the cap-exempt H-1B organization, either part-time or full-time. So that's nice for those four organizations, but how does that help the vast majority of people who need an H-1B, but it's not to work for one of those four cap-exempt organizations, but it's to work for a regular for-profit company? Well, there's two ways that regular for-profit companies can obtain a cap-exempt H-1B by collaborating with one of those four cap-exempt organizations. The first way is the program that the Build Talent Labs is currently running, the Build Fellowship. And here's how that works. A cap-exempt organization such as the Build Fellowship program, which works with nonprofits affiliated with universities. That's one of the four cap-exempt organizations. And if a nonprofit affiliated with a university files a part-time H-1B petition for a foreign national, let's say he's a Swiss national, and they offer a part-time job, it could be as little as 5 hours a week, and that petition will be immediately adjudicated by the U.S. Immigration Service because there's no cap. They can be filed at any time, and the Immigration Service approves it, which they regularly do. Then that foreign national, the Swiss foreign national, can come to the U.S. and work for the nonprofit affiliated with the university for as little as 5 hours a week. And now there's no $100,000 fee. So if he was inside the U.S. and he's filing some kind of a change of status, fine, no $100,000 fee. If he's outside the U.S. and would have had to pay the $100,000 fee, now there's no $100,000 fee. And USCIS is regularly approving these for as little as 5 hours a week. And here's the really interesting part of the first way to get a cap-exempt H-1B. There is a rule that says any foreign national who is inside the United States in H-1B status, even if you didn't win the lottery and you got that H-1B through a cap-exempt, you can have a second H-1B at the same time, as long as it's concurrent with the first H-1B, meaning at the same time. So here's basically the Build Fellowship program. They will work with one of their two nonprofits to get a part-time H-1B immediately because that nonprofit is affiliated with the university and they can file a cap-exempt H-1B immediately. It'll be approved, and then any company, including the foreign national's own startup or any small company, any big company, Microsoft, any U.S. company, can then immediately file their own concurrent H-1B without winning the lottery. They can file their own cap-exempt H-1B by piggybacking on the successful cap-exempt H-1B filed by the cap-exempt organization. So that's how the Build Fellowship program works. There is a second way that the law provides for any for-profit company to get a cap-exempt H-1B by collaborating with a university. This doesn't work for all four of the cap-exempt organizations, but it does work with a university. If the for-profit is willing to physically place the foreign national to work at a university for at least half the working week, in most cases that would be 20 hours, and if the foreign national's work being done has a benefit to the university, then the for-profit company can directly file its own cap-exempt petition. They don't need the university to file anything. They can directly file their own cap-exempt H-1B petition with the U.S. Immigration Service without winning the lottery, without paying a $100,000 fee, and they simply need to prove the normal H-1B requirements, that the job offered is a specialty occupation and that the wage being paid is the fair wage. And they also have to prove that the foreign national will be located at the university for at least 20 hours a week, and that the work being done by the foreign national benefits has some articulable benefit to the university. So those are the two ways that one can benefit from the cap-exempt H-1B program.
Mhm. So to summarize, individuals, a cap-exempt H-1B, they are filed throughout the year. So while there's no H-1B fee all of a sudden, obviously the lottery is over and the next lottery is not until next year. So if an employer was contemplating putting in someone from abroad and who needed consular processing and didn't want to pay the fee, they did not put them into the lottery most likely. And therefore,
Right.
they wouldn't be able to until next year, unless it was a cap exempt employer, because they can file throughout the year. And then you're providing two additional pathways for individuals to suggest that maybe if they didn't put them into the lottery and they're not a cap exempt employer, there are two models that might work for them. One is the option that we run at Build Fellowship, this concurrent employment. You can work part-time for a cap exempt employer and full-time for a non-cap exempt employer, cap subject employer. And then the other is you could maneuver getting your company having an employee located at the university with their work aligned with the university. So there are creative pathways to sponsor H-1Bs throughout the year for companies. And we are obviously willing to talk to anybody about our Build Fellowship program. And Jeff is obviously an expert in helping some startups locate at universities in that different cap exempt creative structure. We did have a question from Siddhant about the Build Fellowship and the cap-exempt H-1B pathway, and he asked if he's eligible with a chemical engineering degree in biopharma. And I think it's worth noting a couple of things about the Build Fellowship cap-exempt H-1B program. Our fellowship hires foreign nationals across literally any specialty occupation, as long as it's a strong case for an H-1B. So if you have a chemical engineering degree, you are hired as a chemical engineering fellow to train students at partner schools with the nonprofit. If you are a zoologist, my new favorite example of one of our fellows, you can be a zoology fellow and you can train students in the field of zoology. It really doesn't matter. We have a wide range of specialty occupations. We work with attorneys, immigration attorneys across the United States to help their company clients with these part-time cap-exempt H-1B positions that do train American students. It's all really a win-win. So yes, Siddhant, you definitely qualify with having that chemical engineering degree. And there was another question about, can a cap-exempt H-1B visa be filed from outside the US and the concurrent be filed after relocating to the US and after the cap-exempt H-1B is approved? Jeff, if you want to explain that series of events. I can also explain it just about the timing of the approvals.
Yeah, I think the answer is, the quick answer is yes, that is absolutely possible.
Yep.
So the Build Fellowship program, partnering with a nonprofit that's affiliated with universities, can arrange for a part-time H-1B to be filed immediately for this person. Once it's approved, the person can either try to get an H-1B visa immediately and enter the United States with the 5-hour-a-week H-1B, or they can wait until the concurrent H-1B is approved and then go to the consulate with both approvals and show that they're going to be working on both H-1Bs at the same time. We've been mostly recommending the latter because we think it's a stronger way to go to the consulate showing a full-time H-1B as well as the 5-hour-a-week part-time, rather than showing just a part-time 5-hour-a-week H-1B. But it is definitely possible to do this.
That's right. We always recommend a more conservative approach of getting both your full-time visa and the part-time the both approvals while outside the United States and entering in with enough employment that there's no flags at the consulate. Great. And then we also had a question from Sharon Phillips, immigration attorney, who is asking a more nuanced question. Jeff, if you want to click into the Q&A, you can see her question at the bottom.
Yeah.
Do you see Q&A on the right-hand side? That's okay, I can read it.
I see it now. Yeah, I'm sorry.
Okay, great. It's at the top.
What do you think about H-1B cap cases that had a June 30th filing deadline? Nunc pro tunc. I have one of those which was denied under the proclamation because the change of status was denied. So they didn't process the underlying H classification. I filed a 290B, which is an appeal or a motion to reconsider, but thinking about refiling nunc pro tunc with consular notification. So Sharon, you don't tell us why the change of status was denied, but let's assume that it was properly denied. But frankly, if it was denied, they should have approved the H and given you a chance to pay the $100,000 fee. Maybe they did. And then if you didn't pay the fee, they denied it. Should you file a nunc pro tunc? I would say yes. Nunc pro tunc means you're asking the immigration service to backdate either their approval or at least consider a petition that was filed prior to June 30th and to go back and look at it again. I frankly would do both. I might, if you're within 30 days of this being denied, you can still file a motion to reconsider. And in the motion to be reconsider, I would ask for the nunc pro tunc approval without the $100,000 fee because it's now illegal. There is no $100,000 fee. So absolutely, if you haven't missed the 30-day deadline to file a motion to reconsider, actually, we filed motion to reconsider / motion to reopen because they're slightly different things and there's slightly different reasons, but we file both all the time just to make sure they're going to consider both. And I think I would do that quickly before the 30 days run out. If your 30 days have run out and you can't file a motion to reconsider, I would try filing a nunc pro tunc, which I don't think has a deadline of 30 days. You just are asking them to go back and do it correctly under the current law.
Great. We had a question, more general question about organizations that want to hire someone right now and or didn't because of the $100,000 fee and are considering taking action right now. Obviously, as we've discussed, a cap-exempt H-1B concurrent model is a good option. So to the individual who has a company but they're not cap-exempt and they want to sponsor you, as we were saying about the Build Fellowship program, you could work for our cap-exempt entity for part-time work, which gives you cap-exempt status to have your full-time employer file an H-1B immediately. So for anyone on the call who didn't fully grasp that, even if your employer is not cap-exempt, there is still a pathway to get Cap-exempt sponsorship throughout the year if you're willing to spend 5 hours a week training students through our program. So that's that model and should definitely be considered. But Jeff, I also want to ask you a question about what other options exist for companies, because when the $100,000 fee was first put in place, immigration attorneys and even we at Build were forced to think about other pathways, creative solutions to help individuals come to the United States potentially without the H-1B. So while one option is certainly now the Cap-exempt H-1B or, you know, considering these creative structures, can you talk about some other pathways you've been advising folks?
Sure. I think the first thing we look at is what nationality, what country is the foreign national a citizen of, and what nationality is the majority ownership of the U.S. company, because an E-2 visa is an excellent way to bring a foreign national professional worker to the U.S. to work for a U.S. company. But the E-2 does require that the foreign national be a citizen of a country with whom the U.S. has a treaty for investment, and the U.S. employer offering the job to that foreign national must be at least 50% owned by nationals of that same treaty country. So a good example is Great Britain. We have a treaty for investment with Great Britain, and if the U.S. company's 55% or even 51% or even 50% owned by British nationals, then any British national or citizen can get an E-2 to come work for that employer. So E-2 is definitely a must to consider. O-1 is for people who are extraordinary in their field, someone who's risen to the very top. And the U.S. immigration regulations list 8 criteria that an immigration officer will consider. And if you can prove you meet 3 of the 8 criteria, in general, you're going to succeed with getting an approved O-1. So that has to be considered every time. If you can get an O-1 and it's a strong case, that might even be a better way to go than a Cap-exempt H-1B, even without the $100,000 fee. And I also want to point out, J-1 research scholars should definitely be considered. The J-1 program is a cultural exchange program where talented foreign nationals can come to the U.S. for one of many different kinds of cultural experiences and can stay and work for 12 months, 18 months, 2 years, depending on which of the cultural exchange programs you're doing. One of the cultural exchange programs is for research scholars, and we've used this very successfully for all different kinds of researchers. We're using one at a law firm where a lawyer is basically doing legal research all day, every day. We're doing regular scientific researchers absolutely are eligible for J-1 research scholars, and any area of research will work. And one very interesting thing, you can get a J-1 research scholar visa even if you are currently in OPT or have just finished OPT. For many years, that wasn't true. If you've had OPT, you've had your training, you've had your cultural exchange, and they were not going to approve a J-1, but that's no longer true. So
Right.
don't forget about the J-1 research scholar as an option.
And at Build, we just launched a new J-1 cultural exchange program that we will run on behalf of companies. So this is something that companies can now contact us about. We have multiple J-1 sponsor partners who we are working with, and we're really providing a white glove service to companies that are new to the J and don't have the time to manage the training plans and putting this together and managing compliance over time. We're doing the forms to even get that off the ground. So we are doing that with companies. If you're interested in exploring the J program, please reach out to us as well. Jeff, we have another interesting question in the Q&A if you want to take a stab at that one from Arda.
Yeah, from Arda. Arter is talking about a case where a H-1B petition was filed and they did not pay the $100,000 fee. USCIS sent an RFE saying you have to pay the $100,000 fee or we're going to deny this petition. The employer responded saying that the first federal court had stated that the proclamation for the $100,000 fee was no longer enforceable and they shouldn't have to pay. But then came the Immigration Services response in this ping pong game. They then sent a notice of intent to deny saying, well, that may be true. There has not been a decision yet from the appellate court on whether they are going to stay the decision of the lower court pending the litigation. And now, so that the employer did their best to respond to the NOID, and they did respond to the NOID timely, but now there's been this new decision this past Friday. So the employer quickly, which I guess means either Monday or Tuesday, yesterday, or today, I'm already forgetting, today is Tuesday.
Yeah.
Either yesterday or today, the employer quickly sent additional response saying, hey, here's the latest decision. The appellate court has decided. And the question is there anything else they can do? I think you've done an excellent job. I don't know of anything else you can do. One thing that might work, I don't know where you're located, but I am in Boston. And in Boston, we immigration lawyers have an excellent relationship with the U.S. Attorney's Office. Now, they represent USCIS in all litigation. And if this were me and this were in Boston, I would be calling the U.S. Attorney's Office and saying, listen, we're filing a suit in federal court immediately to get a restraining order. But before we do, you should talk to your client, USCIS, and tell them just approve the petition right now, because this litigation is going to look so bad for the government that they are ignoring a federal court order, and the media will be there. And why would you set up the government for this? They should just get rid of this case by approving it now. And so I don't know if you have that relationship with the U.S. Attorney's Office, but it's worked for me and several other attorneys I know in Boston very well.
We're hoping that's not a theme, Arda, of course. Jeff, that was an incredible real-time summary of Arda's question. But thank you, Arda, for the scenario. And if there are other attorneys on the call, obviously, I think everyone is learning real time through collaboration, and that's also why we have these webinars, is to create some space for discussion. If anybody else has some scenarios that they're contemplating or going through, feel free to put them into the chat here. One of the other things that is currently happening that we haven't mentioned quite yet is the new duration of status changes that are eliminating day one CPT options for companies that have individuals who have already gone through a master's degree and they already have received CPT and OPT in that previous degree. And so they're not able to do an additional day one CPT program to continue on with work authorization. Jeff, have you been talking to companies? And as you know, this all relates because obviously companies that are considering day one CPT instead of H-1B pathways or J-1 pathways right now, they have decisions to make. So briefly, just have you talked to companies about this, and what are you hearing?
Yes, we have. This is also new since last Friday. We certainly have done our best to be proactive by sending out a client alert and pointing out in the client alert that if you have been using day one CPT or thinking about it, it's not going to work anymore. So after September 15th, which is like around the corner. So, but we received a phone call yesterday from a client who already had been through several rounds of discussions with us about a cap-exempt H-1B, and they decided to do day one CPT. But they're particularly nervous at the moment. It's almost August. Tuition is due coming up at the end of August, and they don't want to pay the tuition. The company doesn't want to pay it because they don't think it's going to work. And to get the Form I-20, they need to pay, and they don't want to pay. And you need the Form I-20 to apply for day one CPT, and they realize this is not working. And there will be litigation, like in most issues, but they're not optimistic that anyone is going to successfully stop this new ruling by the Department of Homeland Security. So they're switching to a cap-exempt H-1B. And I've already given them the information for bill fellowship. I've given them the information about, is it possible to locate your employee at a university for 20 hours a week? They immediately said, not doing that. They're going to call Bill's fellowship because they don't want to locate their employee for 20 hours a week. And they don't want to take the chance that the government will say, you know what he's doing every day does not really benefit the university. So they're not going to take their chances with that, and they're going to be calling Bill's fellowship. But was just yesterday, and this has only been 2 days, 2 work days since this ruling came out.
Right, right. I'll just continue just chatting about the fellowship for a few minutes because I see there's two questions about this. So Jeff, there's one question about they want to confirm what we had talked about the timing of the petitions being filed. The question is, with the concurrent visa being filed after relocating to the U.S., will USCIS still quote that the federal government will be filing an appeal in the Supreme Court to reverse the lower court stay? Can they still deny the concurrent H-1B for the candidates outside the U.S.?
I'm just reading it. I'm reading the question again. Concurrent H-1B be filed after relocating.
Just briefly, so everyone knows what we're doing at Build, we are filing both H-1Bs while outside the United States, and the individuals will enter in on the full-time H-1B filed. That is what they will put on their DS-160, showing that they do have full-time employment in the United States. They enter in and are able to then work for both employers that have the approval. For years and years, we at Build filed just the part-time H-1B from outside the United States. Individuals enter into the United States, and upon entering, they do file the concurrent visa. It is legally possible. It works. It can be successful. We do not do that anymore. Not even, obviously the $100,000 fee is a factor here. We didn't want to have to pay for two $100,000 fees for folks coming in, and many companies do not. But we also don't want, with increased scrutiny at the consulates, we do not want people entering in on just part-time H-1Bs in general. We only want people entering in when they can show they have a substantial enough amount of work in the United States. So that's a decision that we have made. Jeff, if there's another part of this question you want to answer,
yeah,
that would be helpful.
Yeah. Yes, there is another part to the question. I think I'm going to rephrase the question. Is it possible that either a cap-exempt organization files a cap-exempt H-1B, or the concurrent employer files the concurrent H-1B? Whether the person is inside or outside the U.S., is it possible that USCIS can fight back and say, you got to pay the $100,000 fee because the Supreme Court hasn't ruled yet, and either the federal government is going to file an appeal or they already have filed the appeal? I say that cannot happen, and here's why. Last Friday, the U.S. Court of Appeals ruled. We are right now saying no $100,000 fee, period. That is the rule unless the Supreme Court changes it. So the fact that an appeal might have been filed by the government to the Supreme Court is not enough to change it until the Supreme Court rules. So whether you're inside or outside the US, if they try to claim you have to pay the fee because an appeal has been filed, that I don't think they'll say it, but if they do say it, that is absolutely not going to fly. Because the rule is the rule right now. There's no $100,000 fee. And I think it would be interesting to distinguish what happened at the lower court, which was, Danielle gave the date, I think it was in June last
June 8th.
month. The lower court said, we don't think the government is going to win this case. And so we're denying the government's request to let the $100,000 fee remain. However, we already know the government's going to appeal, so we're not going to enforce it yet until the appeals court decides. The appeals court didn't do that. The appeals court didn't say, let's let the $100,000 fee stay until the Supreme Court decides. They didn't do that. They said no $100,000 fee. We're making that decision. So there's a big difference between the language of this appeals court decision from Friday and the earlier one from the lower district court. And this is why I'm confident the USCIS cannot demand a $100,000 fee right now until the Supreme Court says otherwise.
Yep. Someone is asking a little bit more about the fellowship program and how that works. So just to be clear, when we have with our Build Fellowship program, which is the part-time cap-exempt employment opportunities, we only are open to these positions are only open for individuals who have employment already in the United States or offers in the United States. So for companies that want to keep an employee here with OPT expiring or some status expiring, or for companies that have individuals from abroad that they are trying to come and bring to the United States on an H-1B, we are able to work with the company and the employer to facilitate this concurrent employment model. We do not work with individuals who don't have jobs. We aren't able to match you with an employer. We get that question 100 times a day. That's not what we do. But if you are a founder and you are starting a US entity and you have traction in that entity and you have some funding in that entity, we absolutely can work with you on the fellowship program. And in fact, the H-1B Modernization Act of last January in 2025, one of Biden's last acts was to actually make it easier for founders to sponsor H-1Bs for themselves. So we are doing this all the time. And if you have a company or you're thinking of starting a company, you will have an H-1B pathway potentially ahead of you in that direction. But we do charge the company. We don't charge individuals for the fellowship. And when we say charge, companies pay us for a cap-exempt H-1B, premium processing, and ongoing programming. Because when a foreign national is in our fellowship, we are a part-time employer of that individual. We are running education programming with universities, and we are paying the individual the fair prevailing wage. So all of that is the price that a company pays to build. It is $3,000 per month that someone's in the program for, which lasts as long as someone continues until they win the next lottery or get a green card approved or an O-1 approved. There's also a salary component on top of that $3,000 that is shared with the company. So ideally, it's a cost to the company of about $3,000 per month. And there, we have more than 500 companies that have done this with us. And we've been doing this for a very long time. So we know how to do it, and we've made a big impact on training the future American workforce. So there's a really awesome model here. If anyone here is interested in exploring it further, definitely contact us. I'm going to put into the chat right now the email to reach our team here at Build. Of course, Jeff can also be reached, and I'll certainly put his email here as well for more general questions. I see someone did ask something about the coming back to school and the end of day one CPT for folks at the same level. We actually have a webinar coming up specifically on this topic. Jeff, if you want to answer that briefly while I put our contact information.
Yeah. Unfortunately for this person, you have already received a Master's of Science from a university in the United States. You're now outside the United States and you want to come back to get another master's on an F1 or J1, but it's in a different field. This will not work. The new F1, J1 duration of status rule says a foreign national cannot have an F1 to come back and get a second degree in the same level, even if it's in a different field. So you're not going to be able to do that. I don't know what else to say about that. But you have, and the question says you've already won the lottery, so I think I'd run with that and try to find an employer to sponsor you for full-time H-1B or part-time H-1B. If they do, you're allowed to pursue part-time education, not full-time. And maybe that helps you out. There's a question now, can you explain what happens to the 60-day grace period clock if a primary H-1B lays you off and you have an ongoing current H-1B with Build Fellowship? I'll start, and if Danielle wants to chime in because she's running the Build Fellowship, but I can tell you, you're legally here in H-1B status. Even if you've been laid off by the full-time employer, you are legally here with a part-time H-1B for Build Fellowship. I think Build Fellowship wants to work with you and make this work. So they're going to give you some time. Some of it has to do with money. If your employer, before they laid you off, they already paid for another 3 months of the Build Fellowship, then you're good to go for 3 more months. Once the money runs out, you are not allowed to pay more money. Only an employer can. So I think at that point in time, Build is going to have to put you on an unpaid leave of absence, which keeps you in valid H-1B status if you are the one that requests the unpaid leave. That's legal. You remain in valid status while you're quickly job hunting to find a new employer. Of course, you need not just a new employer, but you need a new employer who will agree to sign a contract with Build and pay the fees, the quarterly fees that Build charges. So it's a difficult time, but Build has been unbelievable in bending over backwards to work with people in this situation. And in the vast majority of times, it's worked out.
Yeah, it's not an unlimited unpaid leave, but we certainly have, we give ample time for individuals as they are navigating during that period. And we have many, many fellows who have even left the US and returned with new employers on our visa. So we do work with our fellows to make sure that this is something that they can continue to leverage if they're let go. And we know that this is something that's happening, you know, and especially with the rise and fall of many AI companies quickly. Okay, so we are at time. We have a CPT webinar coming up that we're really excited about later in the week. You can follow me on LinkedIn. I put my LinkedIn in here. I'll be in, we'll definitely be sending out the webinar recording as well as the CPT webinar link for people to sign up. And Jeff and my information is in here as well. So we hope that you all learned something today that was of value. And you can reach out to us if you have more questions, but we really appreciate your time and your questions, and we will be in touch. Thanks all. Thanks, Jeff.
Thank you.
Bye, everyone.